Okay, so let's start with the next SEBI regulation, that is SEBI Prohibition of Insider Trading Regulations 2015. This was added in your SPOM syllabus. So let's try to have a quick overview of the entire regulations. We will be covering almost everything from the regulations which is relevant from your exam point of view and from which you will get a fair idea about the regulations. Yes, can we start, everyone? Okay. Okay, once again I am repeating, what is the name of the regulation? Name of the regulation is SEBI Prohibition of Insider Trading. Okay, Insider Trading Regulations 2015, and these regulations had come with effect from 15th May 2015. Okay, either you can refer it directly from your textbook, okay, from your notes, or alternatively I have summarized the textbook notes, your ICI material notes, into small handwritten notes, so you can use the same also. Yes. Okay, now first of all, let's try to understand what do you mean by insider trading. Okay, you must have already seen an overview of the same in the SEBI chapter, in the SEBI Act also, but just because we are doing this, what do you mean by the term insider trading? Can we say some person? Insider trading is something when some person is dealing, okay, dealing, buying, selling, etc., dealing in the company's security. On what basis? On the basis of some confidential information. Okay, that confidential information is not available generally to the public. Okay, it is not a public information. It is an unpublic, it is a non-public information which you are having, and on that basis you are doing the trading, okay, or you are doing some dealing in the company's security. To make some personal profits or to avoid some amount of losses, then in such a case, this method or this concept is called as insider trading. Okay, is the SEBI allowing this or is the SEBI prohibiting this? The SEBI is prohibiting. That's why the name of the regulation is Prohibition of Insider Trading. Okay, now inside these regulations, SEBI is telling that this is prohibited. Okay, now let's see what is prohibited, if some things are allowed, if allowed then subject to what conditions, etc., etc. Before we proceed ahead into the regulation, let's try to understand a few important terms. Okay, few important terms, everyone here. First term that I've written here is the meaning of the term insider. Who will be considered as an insider? See, you cannot say public will be an insider. No. Can we say any particular person who is having that information? Yes, any particular person who is having that particular information will be considered as an insider. Okay, so they have divided it into two parts. Who all can be considered as an insider? First of all, any connected person. Okay, connected person means obviously connected to the company. Ma'am, can you elaborate? Yes, we have the definition of connected person also coming after this. As of now, any person who is connected to the company or any person who is a deemed connected person. Okay, deemed means the law has assumed that even so and so person will be considered as a connected person. That person is considered as an insider because maybe he is closely related to the company, or a person who is in possession or who is having access to the unpublished price sensitive information. Unpublished, non-public, price sensitive information, because of which the prices can be manipulated. Okay, so either a connected person or any other person who is having the unpublished price sensitive information, this person will be considered as what? This person will be considered as an insider. Yes. Now, two more definitions that we need to understand. One is connected person and another one is your unpublished price sensitive information. Let's try to understand what do you mean by unpublished price sensitive information. Okay, just like I told you, unpublished means non-public, means it is such an information which is generally not available. Okay, normally किसी को नहीं मिलता ये information, generally which is not available, and it is some information related to the company or the securities of the company. Okay, information related to the company or related to the securities of the company, generally which is not available. But if that information is made available, okay, if that information is made available, then it will likely affect the prices of the securities. Okay, if you get that information, you may want to buy more and more securities of the company, or if you get that information, you would want to sell the shares of the company. So if it is made available, then it is likely to affect the prices of the company. Such an information is called as what? Such a material, such a crucial information will be called as unpublished price sensitive information. Ma'am, can you give any example? What do you mean by unpublished price sensitive information? Yes. Now let's say you have, before making it public, you have come to know about the financial results of the company. You have come to know about the dividend declaration about the company. You have come to know about some changes in the management of the company. A big influential person is going to join the company, something like that. Okay, or there is going to be some change in capital structure of the company, or maybe there is going to be some merger, amalgamation, demerger, expansion, closure of the company, or something like that. Can we say all such things will materially influence your decision to either buy more shares or to sell the shares of the company? So such information, this was not generally available. Okay, before it went into public, you have that information. Then till the time it is not made public, such an information is called as unpublished price sensitive information. Are you clear with this? And if you are having unpublished price sensitive information, then you will be considered as an insider person. Manageable till here? Yes. Okay. Acha. Another person who was considered as an insider was the connected person or deemed to be connected person. Okay, let's try to understand what do you mean by connected person. Okay, now any person who was associated with the company in the last 6 months. Okay, whenever a particular act was happened, okay, or whenever a particular transaction has happened, you were connected with the company during the last 6 months prior to the concerned act. You were connected with the company directly or indirectly. Ma'am, how? Connected means how? That can be you are in communication, you are in frequent touch with the officers of the company, or you were a director of a company, or you were an officer of the company, or you were an employee of the company, or you are having some relationship between there is some relationship, some business, obviously there is some business or some professional relationship between me and the company. Okay, this should be there during how much time? This should be there during the last 6 months. Today some act has happened and during the last 6 months you were connected with the company. Okay, and because of that you have got access. Okay, and because of that you have got access to the UPSI, that is unpublished price sensitive information. Then you will be called as what? Then you will be called as a connected person. Are you understanding this? Yes. So either if you are a connected person or if you are not a connected person but still you have UPSI, then in that case you will be considered as an insider. Yes. Acha. Then SEBI regulations say that apart from connected person, we are going to deem, okay, we are going to assume some persons as connected person. Okay, we are going to assume such persons as connected person. So even if it was not written in the meaning of connected person, still you will be deemed to be a connected person. And if you are deemed to be a connected person, you will be considered as an insider. If you are an insider and if you are doing trading in securities, etc., then these regulations will be applicable to you. Okay, no need to by heart this list, just go through this once. Who will be called as a deemed to be connected person? So connected person we had already studied about. Immediate relative of connected person. Okay, immediate relative of connected person. Let's say I am the connected person. So my immediate relative, that is my spouse, my children, my parents, my siblings, okay, will be considered as immediate relative of the connected person. So even they will be called as a connected person. Okay, similarly, holding company, subsidiary company or associate company of the connected person, even that will be deemed as connected person. Then intermediary as per SEBI. Intermediary as per section number 12 of the SEBI Act. Do you recollect? Investment bankers, portfolio advisors, merchant bankers, etc. Even those people, because they are related to the company. Okay, because they are related to the company. Because they are related to the securities of the company, they help the company to facilitate the transactions, etc. So even they will be called as deemed to be connected person. Okay, similarly, a company's holding company, a company's associate company, a company's subsidiary company will be called as a deemed to be connected person. Then our investment company, our trustee company, our asset management company, our mutual funds, okay, these people will also be called as my deemed to be connected person. Then officials of stock exchange where my securities are listed, officials of NSE, BSE, let's say for example, even they will be deemed to be connected person, and if they are also doing trading, okay, then even they will be considered as insider. Yes, similarly, my company is having some dealings with a public financial institution, with a banker, etc. Then even that banker will be considered as a deemed to be connected person. So basically, connected person, okay, so basically connected person can be an individual also. Okay, it can be an individual who was associated with the company during the last 6 months, or now my company's related persons, okay, or my company's linked persons, like my holding, associate, subsidiary, banker, PFI, investment company, AMC company, all these will also be considered as deemed to be connected persons. Are you clear till here, everyone? Yes? Okay. Shall we go ahead, everyone? Yes, so this was the basic. Okay, as of now, just remember the two definitions. One is the meaning of the term insider. So a connected person and deemed to be connected person, or any person who is having access to the UPSI will be called as an insider. UPSI is that material information which was not generally available, but if made available, then that may prejudicially affect the prices. Okay, just remember this much till here. Okay, now let's go to the main regulations. Okay, let's go to the main regulations of the chapter. There are going to be three main regulations. One is regulation 3, regulation 4 and regulation 5. Okay, these are the most crux of the entire regulation. Now regulation 3 talks about communication, okay, telling, communication or sharing or procurement, availing, taking, procurement, purchasing, taking of UPSI. Okay, so now can you normally tell me, will communication or procurement of UPSC be allowed or will it be prohibited? Okay, let's say I have UPSI with me. Okay, so can I communicate this with any other person? Answer should be no. Okay, should I procure UPSI from any other person? You would want to, but that is as per regulations, it is not allowed. Yes, okay. Now in this particular thing, I have divided the entire regulation into 8 points. Okay, and I have simplified here and mentioned it. Okay, now see, first thing that they are telling is an insider. Okay, that connected person or who is having UPSI should not communicate, should not provide, or should not allow access. He should not share this basically with any UPSI relating to the company or the securities of the company with any person. Prohibited. सीधा ना बोल दिया. Okay, नहीं चलेगा. You cannot communicate. And next one, any other person. Okay, any other person should also not procure the UPSI from any insider. Okay, let's say there is an insider. Let's say I am the insider. Let's say I am the connected person. I should not share it with any other person, and you should not even procure it from me. Are you understanding? So this is prohibited. Basically, any dealing of UPSI information or any sharing of information of UPSI is totally not allowed, but it will be allowed in 3 circumstances. 3 exceptions are given there. First one, if you are sharing it or if you are acquiring it for legitimate, genuine purpose. Okay, ma'am, what do you mean by legitimate? So that will be written in the company's code of fair disclosure and conduct. Okay, ma'am, what do you mean by legitimate? As per you, this is legitimate. As per me, this is not legitimate. So no, we are going to check the company's code of fair disclosure and conduct. If we are doing it as per that particular code, if we are doing it as per the company's norms, then it will be considered as legitimate. So if you are doing it for legitimate, that is genuine purpose, allowed. If you are doing it because it is your duty, okay, because you are doing it in course of performance of your duty, it was your duty, company had given you this duty to share this information, then it is allowed. And next, when you are sharing this information because of any legal obligation, imagine SEBI comes and asks for some information, then you have to give it because that is legally required. right? So in these three cases, sharing of information and procuring of information both will be allowed. Are you clear with this? Yes? Okay. Otherwise, except for these three purposes, they are telling you that it is not allowed. It is totally prohibited. Okay. Ma'am, what do you mean by legitimate purpose? I'll again repeat, for legitimate purpose, board will anyway make a policy. It will put it on its website that what is legitimate purpose, what is not legitimate purpose. You have to do the transactions as per that code of conduct, right? And next, yes, now let's say because of legitimate purpose, okay, because of legitimate purpose, I have shared this information with you. I was an insider, I have shared this with you because of legitimate, genuine purpose. Allowed or not allowed? Allowed. So now, can I say I have shared this information with you? So even you will become what? Even you will become an insider and you will be required to maintain confidentiality. Okay, very logical now. If I am sharing the information with some other person due to genuine reasons, then even you will be deemed as an insider and even you are required to maintain the confidentiality. Are you clear with this? Okay. Then after that, sometimes it can so happen that we are sharing UPSI. Okay, we are sharing that unpublished price sensitive information. We are sharing it freely. We are sharing it. First of all, freely sharing was not allowed. But if the board of directors of the company think that, okay, board of this listed company, hey, first of all, this should be a listed company, then only SEBI regulations is applicable. So board of directors of the company think that it is in best interest of the company. Okay, it is in best interest of the company that we should share. Then this is no more an unpublished price sensitive information. Okay, or the board of directors will anyway share this information publicly 2 days before the proposed transaction. Let's say there is a news about merger, demerger, etc. So whenever the merger or demerger is going to happen, 2 days before that, anyway the board is going to share it publicly. Then no problem. Then if I have this information, then even I can share it, because anyway it is in best interest of the company, and anyway the board of directors is going to share this information publicly even before the transaction is taking place. Are you understanding this? So three exceptions that we had studied earlier was legitimate purpose, performance of duties, and due to discharge of legal obligations. That is allowed. And next one, when it is in the best interest of the public, when it is in the best interest of the company, then it can be shared. And when the board is anyway going to share it at least 2 days prior to that proposed transaction, then also sharing of UPSI can be done. Yes, acha. In all the other cases, whenever we are sharing UPSI, okay, whenever we are sharing UPSI, the parties will have to execute an agreement. Okay, just like check the fourth point on the board. Let's say if I am sharing UPSI with you for some legitimate purpose, I am allowed. There is no mistake of me. Yes, but then we will have to enter into an agreement. Okay, which agreement? We will have to enter into a confidentiality agreement that yes, see, I am sharing it with you because of legitimate purpose. Okay, but you should not share it further. That will be mentioned where? That will be mentioned in the confidentiality agreement. Right? And then the last 2 points, where like whatever is our UPSI. Okay, whatever is our UPSI. See, there are some things about the company which never come out in public. Okay, so those information, this UPSI is required to be maintained. Okay, digitally we have to maintain it in a structured digital database. Can you see this? Yes, in a structured digital database, this information should be saved. Okay, what are we going to save there? First of all, the information, the most important information. Okay, then with whom we are sharing. Okay, with whom we are sharing, we are going to put that person's details also. We are going to put his PAN also. Okay, so whatever is the hidden thing that we are not going to make it public now, that information will be stored in the structured digital database, and this will be preserved for a period of 8 years. Okay, at least for a period of 8 years, even after the completion of that relevant transaction. Okay, let's say today we have decided that we are going to demerge our company. Okay, one company getting demerged into two parts or into two companies, let's say. As of now, this information is not going to come out. If this information is not going to come out, it is going to be an UPSI. It is an important information, so it is going to be a UPSI. So the board of directors will put it in the structured digital database. Then it will be saved in the structured digital database for a period of 8 years. 8 years from when? After the completion of that transaction. So once demerger happens, after that also we have to keep it saved in the SDD. Yes, and ma'am, what is this SDD? So SDD is basically a digital database for which there are third party vendors. Okay, there are outsiders who provide us this particular service, and their server or their database can be situated here in India or it can be situated outside India, doesn't matter. Okay, but you take the help of a third party, you use their database, you use their space where you save your information. Are you clear with this? Yes. So this is, first of all, they had told that communication, procurement, etc. is not allowed, and then they gave us few exceptions that it will be allowed for legitimate, genuine, and all those purposes. Okay, all these things are written where? All these things are written in regulation number 3. Whatever we studied, that was written in regulation number 3. Okay, now going on to the next regulation. Next regulation is also important. Okay, next regulation is your regulation number 4. Now, see, in the previous regulation, they were just talking about communication of the information, sharing of the information, or procuring of UPSI, etc. Now, let's say, okay, I did not communicate, I did not procure, everything is okay, but I am having UPSI. If I am having UPSI, then can I say I become an insider? Right? Now, if I am an insider, can I do trading in securities? See, communication procurement was not allowed. That was as per the previous regulation. Now I am asking, can I do trading in securities? So by default rule says what? By default rule says that no. No, the trading is prohibited, not permitted. The trading is prohibited. Or no trading is permitted, whatever. No. Okay, no. Trading is totally what? Trading is totally prohibited. Are you clear with this? Ma'am, very logical. Why trading is prohibited? Because you are having UPSI, you are having such information because of which you can do some personal profits or you can avoid some losses. Okay, so that is totally not allowed. That is told in regulation number 4. But in some cases, okay, in some 6 odd cases, you can prove your innocence. Okay, you can prove your innocence. They have given you some exceptions and they are telling you that, okay, you can do the transactions. Okay, you can do the transactions, in which cases the trading is allowed. So if the transaction is an off-market trade, means it is not done on the recognized stock exchange, it was an off-market transaction, then in that case, it can be done, no problem. Okay, provided you prove the fact that you are not doing it on the basis of UPSI. Okay, and this insider will give the information to the company that we have done an off-market transaction within 2 working days. Okay, within 2 working days, we will inform it to the company and then company will notify it to the stock exchange within 2 trading days. Yes. So off-market transaction is allowed. Next one, block deal transaction. Block deal, you must have heard about block deal window mechanism or block deal transaction, where bulk shares, exchange of shares happen between 2 or more persons. Then again in that case, it is allowed. Trading of that is allowed, provided there should be no violation of regulation number 3. Yeah? There should be no violation of regulation number 3. That is, no procurement or nothing related to UPSI should have been done. Okay, or you can do the trading if it is done as per some statutory or regulatory obligation. You are doing it as per law. Okay, so there is some other law which is permitting you to do that transaction. That even if you are an insider, then you can do, no problem in that. Or you are doing this transaction which is related to stock options, ESOP. Okay, so now let's say the vesting period has just got over. So now the stock options have to vest. Okay, or you have to exercise the stock option. So here the exercise price at which you are going to get the company's share, that was predetermined. That was predetermined, means it is not on the basis of UPSI. So in that case also the trading can be done. Okay, example, employees of the company will be exercising their stock options now. Employee of the company are connected persons. If they are connected persons, they are insider also. So is trading allowed or is trading prohibited? So if they are doing trading related to ESOP, then it is allowed. Yes. Acha. Then next one is a little important one. If you are doing the trading as per trading plans, okay, means you already had a plan. Okay, irrespective of this UPSI. Okay, irrespective of this UPSI, you had already made a 1 year long trading plan that you are anyway going to buy shares of the company on so and so intervals, or you're going to sell the shares of the company at so and so intervals. Okay, then in that case, it can be done. Okay, trading plans is described in regulation number 5, which we are going to do in detail. So if you're doing it as per a advanced of a framed trading plan, then it is not a problem. And last one, if the trading is done by non-individual insiders, okay, non-individual, let's say a company, subsidiary company, or some organization, etc., if they are doing the trading, then it is allowed, provided there is a condition there, that the individuals who were having UPSI, okay, there were some individuals within that non-individual insider. Let's say there is a company, okay, which is a non-individual insider. Within that company, there are some individuals who are having UPSI, and there are some individuals who do not have UPSI. And the trading decision is taken by the person not having UPSI. There is a particular company. Within that company, there are many individuals. In that, there are two different group of individual. One individual having UPSI. These people cannot take the trading decision. But there is another group of individuals who are not having UPSI. Then they can take the trading decision, and the trading can be done even if they are called as insider. Yes. So again I am repeating, by default trading is not allowed. But in these 6 circumstances, trading is allowed. What are the 6 circumstances? First one, off market transaction is allowed. Okay. Then block deal mechanism is allowed, provided there is no violation of regulation number 3. If you are doing it as per statutory obligation or as per legal obligation, it is allowed. Okay, if you are doing it due to stock options where exercise price was predetermined, it is allowed. If you are doing as per the advancedly formed trading plan, then it is allowed. If you are a non-individual insider, but the trading decision is taken by such a person who was not having UPSI, then also the trading will be allowed. Are you clear with this? Except for this 6. Okay, except for these 6, trading allowed or trading not allowed? Trading is not allowed. Okay, trading by insider is not allowed, or trading by connected person is not allowed. If such person does trading, if such connected person does trading, burden of proof, onus of proof is going to be on such connected person. Means we are anyway going to hold that connected person guilty. Okay, he is anyway guilty. Now we are going to tell him, if you want to prove yourself innocent, you only have to prove it. Okay, and in case of others, in case of other than connected person, any other outsider, if we want to hold him liable, the burden of proof is going to be on the SEBI. Means SEBI will have to prove that, okay, that person will also be considered as an insider. Are you clear with this? Okay, so this was the first point. By default, no trading is prohibited except in case of 6 exceptions. And the second point was burden of proof. Are you clear with this? Yes. So regulation 3 was talking about not sharing the information. Regulation 4 is talking about not doing trading in such transactions by the insider. I hope I am very, very clear till here, everyone. Yes. Okay, then after that, going to the next one, that is regulation number 5, which talks about trading plans. Okay, remember trading plan was one of the exception. Means if the insider is doing the trading as per trading plan, then it is going to be allowed. No problem in that. Now, ma'am, what do you mean by trading plan? Now, if there is any insider, if he has already made up his mind, not on the basis of UPSI, but on the basis of his knowledge, but on the basis of his experience, okay, then what he will do is, he will formulate a trading plan. Okay, trading plan can be buying the shares, disposing the shares, anyway, dealing in the shares. He will prepare a plan. He will give it to the compliance officer of the company, CS. compliance officer of the company for approval. Compliance officer, if he thinks that it is good, then compliance officer will give a public notice of the same, that so and so insider has given me a trading plan where he wishes to buy or sell the securities of the company. Okay, and once the public disclosure is done, then after that we can do the trading as per trading plan. Okay, we can do the trading as per trading plan. Means, are we dependent on the UPSI, or we have already made our different trading plan? We have already made our different plan. Okay, we have already made our different trading plan. We are not dependent on any UPSI. I simply want to do that transaction, for which in advance itself I have given a trading plan to the compliance officer. Now the compliance officer cannot tell me that Arpita, you cannot do trading in the company. Okay, because we have informed it to the compliance officer also, we have given a public disclosure of the same also. Yes, okay. Now there are some restrictions for this trading plan on that particular person. Now, before giving the public disclosure, he cannot do the trading 6 months before. Okay, read this. Such insider person shall not do trading earlier than 6 months from public disclosure. Okay, so whenever you are giving public disclosure, before that, in the last 6 months, you cannot do. So basically it can be done only after giving the public disclosure. Okay, another thing, he cannot do trading between, this is a little different, between 20th day prior to the last day of the financial period. 20th day prior to the last day of the financial period for which the results are to be announced. Let's say results are going to be announced for 31st of March 2024. So 20 days prior to this, approximately 11th of March, from 11th of March, can we say now we are going to declare the results for 31st March 2024? Yes, so from 11th of March, 20 days prior, from 11th of March till the second day after disclosure, second trading day after disclosure of financial results. Let's say we are going to disclose these financial results. Let's say, for example, okay, I'm taking a random date. Let's say we are going to disclose the transactions on disclose the results on 2nd July 2024. So, second day after the declaration. So, till 4th of July. So from 11th of March till 4th of July, no trading can be done, because otherwise someone can point out and say that you are doing the transactions on the basis of financial results. Okay, you are doing the transactions on the basis of financial results. So they are telling that trading during this period is totally prohibited. Okay, then whatever trading plan you are giving, that should be at least for a period of 1 year. Okay, at least for a period of 12 months, it should be there. And once that 12-month, whatever is your trading plan time period, once that gets over, only after that you can submit a new trading plan. Means there cannot be any overlapping. Let's say I have given a trading plan from this January to December. I cannot give it before, I cannot give a new plan before December. I have to give it from next January onwards only. So there cannot be any overlapping. Okay, there cannot be any overlapping, and whatever you are writing in the trading plan, you will have to also mention how many shares are you going to sell, how many securities are you going to purchase or sell, what value of securities are you going to purchase or sell, at what rate, etc., etc. Full details have to be written in the trading plan, and you should not be doing this trading for market manipulation, for market abuse. Last point, for market abuse, for market manipulation, no. It should be for, you have to give a declaration that you are not doing it for market manipulation. Means, can we say here we had already given a well thought plan to the compliance officer that I want to purchase or I want to sell these many number of securities over a period of next 12 months at least. So even if I am an insider, I am not depending on which information, I am not depending on UPSI. I have already made my own plan. So please allow me to do the trading of the same. Okay, so if you have submitted a proper trading plan to your compliance officer, and if a public disclosure of the same has been done, then that will be covered in the exception and you will be allowed to do the trading. Are you clear with this? Yes, and compliance officer will review the plan. Once approved, the plan is irrevocable. Now you cannot take it back. whatever number of shares, whatever value of securities you have committed, that much transactions you have to do it compulsorily. Yes, and once approved, the compliance officer shall notify the plan to the recognized stock exchange also that, sir, this person has given us the trading plan and we are going to allow him to do the transactions. Are you clear with this? Okay, so trading plan is a very nice thing where you, even if after being an insider, you can still do the trading in securities of the company, provided you submit a proper plan to the compliance officer of the company. Manageable till here? Okay. And then going on to the last two parts of the regulation, that is disclosure of trading. Okay, that is whenever any trading, disclosure of trading by insiders and by other persons, etc. So here they are telling that whoever are the insiders closely related to the management of the company. We are talking about some category of insiders, like the directors of the company, like the KMP of the company, promoters of the company, etc. Whenever they get appointed in the company, okay, whenever they come in the company as KMP, as director, as a promoter, as a member of a promoter group, etc., as soon as they are appointed, within 7 days, okay, as soon as they are appointed, then within 7 days, they have to disclose their holdings. Okay, where all you are holding securities, please disclose it. So these selected insiders will disclose it to the company, and then the company will notify it to the stock exchange. Ma'am, which stock exchange are we talking about? Where our company securities are listed. We will notify it to the stock exchange within 2 trading. Okay, this was an initial disclosure. Okay, can you see here on the left hand side, everyone? This was an initial disclosure, that is within 7 days from their appointment. Once initial disclosure is done, after that they are also required to do some continuous disclosure. Okay, they are also required to do some continual disclosure. That is, if these people, same director, KMP, etc., if they have done any dealing in securities of the company of more than rupees 10 lakhs, okay, if they have later, after their appointment, if they have done a dealing in securities of the company for a value of more than, greater than rupees 10 lakhs in each calendar quarter, not calendar year, in each calendar quarter, Jan to March, April to June, July to September, October to December, in each of the quarter, if in any quarter, if they have done a dealing of more than rupees 10 lakhs, either buying or selling, okay, either one transaction or aggregate of transaction, but in one quarter they have done a transaction of more than rupees 10 lakhs, then also they are required to inform about this to the company, and then the company will go and inform it to the stock exchange. So initial one was required to be done. Initial one was required to be done within 7 days of their appointment. This continual disclosure is required to be done within 2 trading days. Okay, within 2 trading days, whenever they have done the transaction from that day, within 2 trading days, they have to inform it to the company. Company will notify it to the stock exchange within 2 trading days further. Are you clear with this? Okay, so this was by some specific insiders. This disclosure was required to be done by some specific insiders and by other persons. For other persons, the company can say that we will tell you when are you supposed to do the disclosure, at what frequency, at what intervals you are supposed to do the disclosure. So here they have placed more focus. Okay, here they have placed more focus on those specific insiders, and for other connected persons, company will tell them when are you supposed to do the disclosure whenever they are doing some trading in securities of the company. Are you clear with this? Yes. And now going on to the last part, that is some codes. Okay, now regulation, SEBI regulation tells to the companies, tells to the listed companies, etc., that you have to document, you have to prepare, you have to document some codes. Okay, ma'am, which 2 codes are we talking about? One is the code of fair disclosure and the second one is code of conduct. Now, ma'am, what do you mean by code of fair disclosure? Code of fair disclosure. Now, for this purpose, they are telling that board of directors of the company, okay, BOD of the company will make rules and regulations. Code is nothing but a set of rules and regulations for fair disclosure of UPSI. Remember, you can do disclosure, you can do communication of UPSI in case of legitimate purpose, disclosure of legal obligations and all those things for performance of duties. So in which cases will be called as legitimate, which cases will be called as performance of duties, that will be mentioned in this code of fair disclosure. So board will make a rule for that. It will publish it on the website. Yes, similarly, it also is required to prepare one code of conduct. Okay, code of conduct that will be prepared by the board of directors of our company and board of directors of the intermediaries, that is stock exchange, SEBI, etc., and shall ensure that CEO or MD shall make. Okay, here the board is ensuring, board is not making. Here the CEO or MD is making. Whereas in the first one, it was made by the board. So CEO or the MD of the company will make the code of conduct to regulate, monitor and report trading by its designated person. So whenever it's, ma'am, what do you mean by designated persons? We have it coming here. Okay, so whenever its designated persons are doing some trade, so that trading should be done as per the code of conduct. Code of conduct is prepared by whom? Code of conduct is prepared by the CEO or MD of the company. Okay, and that will be checked by whom? That will be checked by the board of company and board of the intermediary. Yes, and this will be made, this will be administered, this will be checked by the compliance officers of the company. Yes, ma'am, who are the designated persons? So employees of the company, employees of the intermediary, employees of our material subsidiary, all promoters of the listed company, etc. Whenever they are doing some trading, okay, whenever they are doing some permitted trading, they have to do it as per code of conduct. Okay, so both the codes are altogether different. Code of fair disclosure talks about how to or in which circumstances can we disclose UPSR, and code of conduct is whenever some designated persons do the trading, then it can be done as per the code of conduct. Are you clear with this? And last, code, this part was a one-time read. You just have to understand it once, no need to by heart it. And last thing, that is penalty under section number 15G. That is, if someone is found guilty of insider trading, then penalty we have already studied in our SEBI Act, not less than rupees 10 lakhs, or which can go up to 25 crores or 3 times the profits earned out of insider trading, whichever is higher. Do you recollect that? So I am not repeating it here. I have not written it in the notes also again. I hope this much is manageable, everyone. Yes. Okay. So this was all about your prohibition of insider trading. Please read it in parts. And I think in the entire lecture, we have understood it in a very summarized manner, which is sufficient, very much sufficient for your examinations. Yes, and yes, if you want these notes, I will be putting it on our website in the free note section. Okay, on arpitatulsyan.com, in the free note section, I will be putting these handwritten notes so that it will become simple for you to refer it. Yes, I hope you could understand the concept of prohibition of insider trading and what are the ifs and buts of doing the insider trading. If yes, do let me know. Thank you so much.